The journey has been long, 30 years, 3 decades. Having started off as an informal association where the lawyers were operating from their offices. I think if you know the history of the country, when Zimbabwe Lawyers was established, or when the idea came about in the early 90s, it's the time when we were having economic shifts, where we were now having the economic structural adjustment program. And there were issues around the economy, there was inflation, there were student protests, particularly in the tertiary institutions such as the University of Zimbabwe. And there was a lot that was going on around that time. So the lawyers were concerned about the human rights trajectory. At that time, when they came together, they formed this organization, which started off operating informally. It was not institutionalized. And then it was eventually institutionalized in the early 2000s, 2002. And from then, we have a secretariat with 3 offices. This is the national office at the Harare office. And then we have regional offices in Mutare and Bulawayo, covering the different regions and the provinces. The journey has been interesting, but also difficult sometimes, but the lawyers have remained resilient. The lawyers have faced attacks, particularly when they deal with human rights issues that are not in line with the policy of the ruling party at that time, or when they are assisting human rights defenders who are setting and demanding their rights, particularly those that are holding dissenting voices. We have seen lawyers being attacked and being associated with because of their clients. And it has also been difficult because as lawyers, when you go and stand in court, you want to defend your client to the best of their ability. But sometimes it has been very difficult that you appear before the courts, you do not manage to get the relief that you want for your client. We have had what we call politicization of some of our cases, where simple matters like bail matters are not determined as we would want them to be determined, without interference. And if you were following in 2019, when there were many people who were arrested following the protests, the spontaneous protests early in January, we had many cases of people being denied bail. And we also protested because we were concerned that there was interference with the independence of the judiciary. I think if you remember that protest, which was well subscribed, we have, in the past 30 years, we have had to demonstrate where we feel that there's interference, particularly with the judicial system. Because for us as lawyers, that is where we are headed. That is where we can defend our clients. The other challenges that we have faced have been challenges around the fact that it's quite difficult sometimes to operate in a very constrained environment, especially over the last 4 or 5 years, with the moves to regulate civil society, civic space. And Zimbabwe Lawyers for Human Rights, we are a member of the Law Society. Our members are members of the Law Society. They get practicing certificates when they're within secretariat, or the members have practicing certificates when they're operating from their own law firms. But as an organization which is receiving funding from other funding partners and developing partners, we are also supposed to then comply with any laws around regulation of civic space, the regulation of non-governmental organizations as a law-based organization. So the government promulgated the amendment to the Private Voluntary Organizations Amendment Act, and when they did that, it was under the guise that they were complying with the Financial Action Task Force recommendations on countering terrorism and also dealing with money laundering, preventing money laundering. But we all know that that was not the real case. The real case was around control. And of course, it has been a very difficult journey for us to continue to engage government to say, but we do have freedom of association, freedom of expression, and any laws, even the amendments to the PVO Amendment Act, should comply with the Constitution and respect our rights to association and assembly. So yes, it has been a difficult journey. We have had instances where court orders have been defied, where we get very good court orders to protect the rights of our clients, whether they are victims of ongoing human rights violations or they are victims of future violations. And then we've had instances where, for instance, you get awarded monetary damages when you are tortured or when you are assaulted, especially by the state enforcement or the state security agents. We have had instances where those court orders or judgments are not honored, and then when they are not honored, we've had to go back to court to get what we call contempt of court. So that has sort of like increased the costs for us, because we're going to court a lot. We're going to file to compel them to comply with court orders. That's why I think when you saw us protesting, we had a sign that was written, "Stop defying court orders," because we believe that there are three arms of government. There is the judiciary, there's the legislature, and then there's the executive. And they're supposed to be providing checks and balances. And first, the judiciary is particularly important. If there are violations of human rights or the executive excesses, then the judiciary should be able to step in to correct that. That's their constitutional obligation. And that role is actually recognized in most of the human rights instruments that Zimbabwe has ratified. So in a nutshell, that has been the journey, but we remain resilient as Zimbabwe Lawyers for Human Rights. Thank you.